Hello and welcome to Rajya Sabha television. You're watching The Big Picture with me, Frank Rausen-Pereira. In an announcement with massive repercussions for Jammu and Kashmir, Home Minister Amit Shah announced in the Rajya Sabha that the government has repealed Article 370 of the Constitution, which grants special status to Jammu and Kashmir. The government also decided to bifurcate the state into two union territories, Jammu and Kashmir, which will have a legislature, and Ladakh, which will be without a legislature. Shah's announcement was immediately followed by massive uproar in the upper house, with opposition MPs protesting in the well of the house. Back in the valley, three of Jammu and Kashmir's most prominent politicians, Mehbooba Mufti, Omar, Abdullah and Sajjad are under house arrest amid a massive security build-up in the state. Internet services and mobile services have been suspended in several places, and all public gatherings are banned in Srinagar district as Section 144 was imposed from midnight. On this edition of The Big Picture, we will analyze the implications of abrogation of Article 370. Joining me on the program today are Satya Prakash, legal editor of the Tribune, J. Sai Deepak, advocate of the Supreme Court, and Rana Banerjee, former Special Secretary, Cabinet Secretariat. Thank you to all my guests for joining me on this edition of The Big Picture. J. Sai Deepak, I'd like to begin with you. What changes now that Article 370 has been abrogated in Jammu and Kashmir?
So, I've been trying to reconcile news reports with the actual document. And from what I understand so far, 370 in itself has not been abrogated. So, the document in fact says one thing. In fact, Para 1 says that the power of the President under Article 370 subclause 1 has been invoked for what purposes? 1. To replace the Constitutional Order of 1954 with the Constitutional Order of 2019. That's point number 1. Which means all amendments to the Constitution or all application of the Constitution to the state of Jammu and Kashmir under the 1954 Constitutional Order stands replaced and superseded by the current order. Now, Para 2 of this order also makes it abundantly clear that all provisions of the Constitution as amended from time to time shall apply to the state of Jammu and Kashmir except for the changes made to Article 367. Now, what does this mean? The byproduct of Article 370 was the creation of a separate constitution for the state of Jammu and Kashmir. Now, just a bit of timelines here. The Constituent Assembly of the state of Jammu and Kashmir was created in November 1951 after the Indian Constitution came into force in January 1950. The Constituent Assembly framed the Constitution in September 1956. Okay. Now, 370 was meant to be a temporary provision which decides the working relationship between the Union and the state pending the framing of that particular constitution for the state of Jammu and Kashmir. And therefore, 370 automatically goes along with the creation of a constitution. Now, by application of the Indian constitution in its entirety to the state of Jammu and Kashmir, the constitution of the state of Jammu and Kashmir has been replaced with the constitution of the Republic of India. Therefore, from now on, hopefully, all our barracks will say that this act shall apply to the entire or the whole of country or the whole of India, and there will not be those words except the state of Jammu and Kashmir. That is the basic consequence.
So, from Kashmir to Kanyakumari basically.
Exactly. Then the third important change that has been made according to me is the change that has been made to the proviso to clause 3 of Article 370. All these days, whenever Article 370 was discussed, the discussion revolved around whether the President can invoke his powers under Article 370 clause 3 to issue a public notification saying that this particular provision shall cease to be operative from so and so date. However, it was connected to the proviso which said, provided that he shall receive the recommendation from the Constituent Assembly before doing such a thing. Now, if the Constituent Assembly ended in September 1956, there was no question of the operability of that particular provision post 1956. Therefore, the reference to Constituent Assembly both in clause 2 as well as clause 3 has been replaced with the Legislative Assembly of the state. Now, apart from 372 and 373, entirety of 371 refers to the government of the state. And the government of the state all these days has been interpreted, in fact from 1952, as the reference to the governor of that particular state acting in advice of the Council of Ministers. This is pursuant to the Delhi agreement between Sheikh Abdullah and Nehru, where they decided that Sadr Riyasat shall be changed to the reference to the governor, and how shall the governor act. But if you look at the Constitution of Jammu and Kashmir and read it with the provision for the appointment of governor in the Indian Constitution, it's the same thing. The President shall appoint the governor. So effectively, 371 has been taken pursuant to the power of the President along with, let's say, the concurrence of the government of the state, which means the governor, and therefore the entire Constitution has been applied. So, according to me, 370 remains. It has not been abrogated, but 371 has been used to render the Constitution of Jammu and Kashmir redundant.
Right, right. So now the next big question, Satya Prakash, is does all of this, pass judicial review? Do you think that's going to happen? Because this is going to be taken to the courts.
I'm sure it will be taken to the courts, and maybe tomorrow, day after, it will happen very soon. The only question will be, the ultimate challenge would be whether it violates basic structure of the Constitution or not. Since the chapter itself, the part 21 of the Constitution itself talks about temporary and transitional provisions, I don't think it can be challenged on the ground of basic structure. There are certain historical facts, and since 1950s, much water has flown into the Jhelum. So you cannot put the clock back. There are several issues relating to Jammu and Kashmir, including India, when India took it to the United Nations, and there was a word given by us that we'll hold plebiscite in Jammu and Kashmir. But there are certain preconditions for that never happened, and I don't think it will happen ever, because parts of Jammu and Kashmir has been given by Pakistan to China in 1963, and before that they were supposed to vacate the entire area they occupied. They did not, and hence nothing moved forward. The real question over here was, can you have a separate discriminatory state within the secular Indian Republic, which guarantees fundamental rights to every citizen? Because in Jammu and Kashmir, because of Article 35A, it was completely a discriminatory regime. It violated against the woman. It violated the basic fundamental rights of the Balmikis, who are now settled over there. It violated the basic fundamental rights of the people who came from West Pakistan. So can you have this kind of discriminatory regime on the basis of a separate constitution, which itself, the very first article of Jammu and Kashmir Constitution says it shall be an integral part of India, and Schedule 1 of Indian Constitution also mentions Jammu and Kashmir as one of the states of Indian Union. So that was the real question, and since it was a temporary provision, it had to go. It was only a matter of time and the political will to be displayed by the government at the center. And now that the government has displayed the political will, and now the matter is being debated, let's hope that it will pass the judicial scrutiny also. Why I am saying this? Because ultimately, if somebody challenges it on the ground of right to equality, that Article 370 and by Article 35A and by implication Article 370 violated somebody's right to equality, or right to right against non-discrimination, right to live with human dignity, then any constitutional court applying the constitutional principles and provisions and maybe international conventions that we are party to will strike down this kind of provision. Already there were several challenges lodged against Article 35A and Article 370 before the Supreme Court. With this decision,
right,
those petitions will become infructuous.
Sure. So, Mr. Banerjee, does this now become easier for the authorities to deal with the problems of Kashmir going forward?
Yes, certainly. As a former practitioner dealing with security connotations and terrorism in the state, which has been chronic almost, I would consider this a very momentous and even bold decision, where in one fell sweep the central government has taken such a step, and the crux of making it a success would depend on how well the ensuing civil security situation in the state is handled, and how well threats being instigated from across the border to create turmoil and civil strife in Jammu and Kashmir can be contained. If that can be done effectively, then I think the government would be sitting pretty. One aspect which I am not so sacrosanct about is the reduction of the status of the state of Jammu and Kashmir to a union territory, albeit with a legislature. But this would tend to give a fillip to the concept of the constitution being more unitary than federal in character. I think in this regard, there should be a stepping back in due course of time, and the status of Jammu and Kashmir as a state, without possibly Ladakh, could be restored as a sort of balm to the injured sentiments of the people there. And if they can handle the security situation there and the sort of tremendous alienation that will be there in the beginning, but gradually if they understand how the benefits could accrue, there is this argument which Mr. Jagmohan has been giving for a very long time in his various edited versions of the book Frozen Turbulence, where he has said that, Article 370 became a vested interest which worked against the development of the state because there was no investment and people from the rest of India could not go and invest, and this could in fact generate more development, more employment opportunities for the people of Kashmir. If that could be ensured and effectively implemented, I think in the overall balance of things, possibly we could have handled this situation well.
Right. So, Jay Sai Deepak, since we are here, now your thoughts on, on two union territories being formed out of Jammu and Kashmir, one with a legislature and one without a legislature.
Before that, may I address Article 35A subject
Yes,
to it?
please.
So, I think one of the most important consequences of this is, and it's always been said that 370 and 35A are conjoined twins. Now, when 35A was introduced as a consequence of and pursuant to the 1954 order, and the 1954 order itself stands superseded, 35A goes along with it. Okay. Now, the power of the president to actually introduce 35A through his powers of 370 was upheld by the Constitution bench in 1961. While I may disagree with that particular judgment, as long as that particular judgment stands, and the Supreme Court has held that it is available for the president to actually invoke his powers under 370 to even introduce a new provision insofar as the state of Jammu and Kashmir is concerned, dehorse the power of the parliament to make a constitutional amendment under Article 368. I suspect that therefore it is available for the president to revoke Article 35A as well and perhaps introduce new provisions such as that has been done under Article 367 today in terms of a new definition. That's point number one. Point number two, I think this will lead to setting the balance right as far as Kashmir is concerned, because Article 35A was effectively the tool under which the definition of who shall be a permanent resident or a citizen was exclusively reserved within the powers of the state, the Kashmir state, which affected employment, representation in government services, scholarships, purchase of property and settlement in that particular state. All of this goes with one fell swoop. Therefore, this is something that can be looked at. I think it's something that we can take serious joy from. Point number two is, as far as your question is concerned, there is a very important letter that most people perhaps are not even aware of, which was written prior to, or rather after accession, but before 370 came into being, so to speak. In May 1949, the president of the Buddhist Association of Ladakh, Chivang Rigzin, he wrote a letter to the Prime Minister, Sri Nehru, at that point of time saying, Ladakh has always had a different identity from Kashmir and it has also been part of Tibet at some point of time. And that it was annexed in 1834 perhaps, even before the formation of the princely state of Kashmir under the Treaty of Amritsar in 1846. Therefore, even if Kashmir, so to speak, decides to stay independent or goes with Pakistan, Ladakh wants to be with India and not with Tibet. That was their position, and we certainly don't want to be an independent state. Therefore, I think we must respect the sentiments of the Ladakhis, who have always believed that they have closer relations and cultural ties with India, and therefore that particular sentiment, I think, is being respected when you have decided to carve out two different states, or let's say two different union territories, so to speak. Now, considering the geostrategic and geopolitical sensitive nature of Ladakh, the fact that it shall be without a legislature and shall be directly under the control of the union perhaps makes a lot more sense. And here, the exchange between the crown between 1846 and early 1900s makes for fantastic reading. That is, exchange between the crown through the Secretary of State for India in the UK with the Viceroy and then with the princely state, at that time Maharaja Gulab Singh and then his son Ranveer Singh, effectively says that this entire region is of geostrategic importance, considering that it gives access to Afghanistan, it gives access to China, it gives access to Russia at that particular point of time. Therefore, apart from our domestic interests, this is an extremely critical region. Therefore, it is fantastic move, according to me, to keep this directly under the control of the union, so that it is shielded from any kind of internal political machination, and it allows the government to ensure that security of that particular place is paramount over and above any other parochial interests.
So, because of strategic, national as well as other reasons it is important that this region stays under the control of the union, is what you're suggesting. All right.
Yes.
Satya Prakash, as far as Article 370 and 35A are concerned, over the past, over the last 70 years or so, what are the kind of problems that they have caused?
Well, primarily because of Article 35A, it created a sort of a division. It empowered the state government to decide who permanent residents of the state are, and those who are considered not to be the permanent residents of the state, they were discriminated against. As Sai has already pointed out, be it education, be it government employment, be it voting rights, in every field, they were discriminated against, despite the fact that they have been living there for generations. So for any democratic government, or for any civilized society to discriminate against their own people, and that too for generations, and despite having a constitution which guarantees basic fundamental rights. I am talking about the Constitution of India. So they were part of the Indian Republic, yet they were discriminated against, despite there being Article 14, which guarantees right to equality and opportunity of equality of opportunity. Despite that, they were completely discriminated against, and they are the ones who will be benefited the most. But one of the fallouts of this, as Mr. Banerjee has pointed out, is about bifurcation, but still you are not making Jammu and Kashmir a state. Its status as a state is gone, and it will be a centrally administered state. As Sai has pointed out about Ladakh, the similar kind of argument can be extended to this place also because of security implications. Maybe the central government doesn't want to take a chance, and if within next 5 years or 10 years or 15 years the situation improves, it can again be given that status. In many parts of India, like Goa was not a it was union territory, Arunachal was a union territory, Nepal, and several other places which have been given a status of a state, and it can happen again to Jammu and Kashmir. But at this juncture, in its own wisdom, the government has decided that it shall not be a state. The only implication is, suppose it is given the status of union territory like we have in Delhi, the law and order and land, it might vest with the administrator. Rest of the powers can go to the state assembly. They can make laws, and accordingly whosoever is the chief minister can exercise those powers with the help of the cabinet.
Sure. Looking forward and talking about security and strategic implications, Mr. Banerjee, we had a similar kind of a problem, separatists and so on and so forth in Punjab as well, but we dealt with that problem long time ago. And now that problem has ceased to exist. Of course, there have been attempts that are made from across the border to try and revive that as well. But do you see a similar kind of a model being applied in Kashmir to deal with the separatist movement there as well? Do you think it's going to work?
No, before I come to that, if you permit, one point I would like to flag, which Mr. Sai Deepak pointed out so well about the strategic importance of Ladakh. We should qualify also concern for the area of Kargil, where they are Shia Muslims, and they should also be brought into the inclusivity aspect of governance of the new union territory. They should not feel left out or feel a sort of centrifugal pull towards Muslim concentration areas of valley. So the Shias have been different and have their own identity, and of course they are different from the Buddhists, but it's also a very vital area. There are some routes from there which go into Gilgit-Baltistan, which we could work to develop later on. So those areas should also be developed with priority. That is one aspect. Regarding your question, you see, it's not going to be so easy because, and the parallels with Punjab don't exactly apply. Of course, the revitalizing of the J&K police has been done, has been carried out much on the Punjab pattern, and it has been also quite successful. But the problems are more complex in this area, and they become more complex because of the militancy aspect and the extent of control or influence that can be exercised from across the border, and that's not going to be given up in a hurry. In fact, what the Pakistanis are likely to do will be two-pronged. One would be to adopt some measures to intensify the infiltration of, non-state actors, what have you, trained militants, to instigate more civil strife and violence here immediately in the aftermath of this change. The other would be to internationally ratchet up the whole issue of the alteration of the status under 370. They would play it up in various ways to go back to history and to the UN resolutions and all that, which will have to be scotched very firmly through our own diplomatic initiatives. So on these two fronts, we'll have to be very alert and active, proactive even. But on the law and order front, the main thing would be to address the alienation of the youth in the valley. If we could convince them that this is a step forward, which will be better for their own future. There is a certain amount of, fatigue with the militancy situation, with the way it has gone in the last 2-3 years after Burhan Wani and the, shifting of the troubles to South Kashmir. There is a lot of, fatigue among families, their parents, among the youth about nothing being done to address the alienation. I think there should be a renewed focus for political outreach to this category of alienated students, emphasizing that this step under Article 370 could be positive for them if they only have a little bit of patience to see how it unfolds.
Sure. Sai, you touched upon this in your initial opening remark, but just to understand the process a little better, why only a notification was enough, and why wasn't there a need to amend the constitution for all of this?
So for this, you have to break up Article 370 subclass 1 into two separate categories. The first set of categories, or rather the first basket, involves the power of the parliament to make laws, and that comes under 370 clause 1, clause A and clause B. Then the power of the president comes under clause D of subclause D of clause 1. Now how does it work? It's very simple. So the instrument of accession is to be taken as the basis, and instrument of accession is the primary document that establishes the relationship between the two entities and not Article 370. 370 only decides the degree of autonomy subsequently. So under 371, what they did is, those issues which are identified in the instrument of accession, which is defense, communications and external affairs, which are relatable to the subject matter in the union list and the concurrent list, the parliament shall have power to make laws with respect to those, with only consultation required from the government of the state. But for those subject matter which fall under these two lists, but which do not relate to these three subjects under the instrument of accession, you need the concurrence of the government of the state. Now this is only for the power of the parliament. Now if you take a look at 371D, it refers to the power of the president to apply other provisions of the constitution, and when it says such other provisions of the constitution, it is other than Article 1 and Article 370, because those two provisions are referred to in C, clause C. So the president can invoke his powers under 371D to apply such other provisions of the constitution with or without exceptions and modifications, and he shall only need to use a notification, so to speak, and again the rule applies, which is, if the order relates to the issues under the instrument of accession, then you need only consultation of the government of the state, and if the order relates to those issues outside the instrument of accession, outside those express issues, then you need the concurrence of the government of the state. This is the procedure. So which is why this particular notification, so to speak, today refers to 371 and not to 373.
Right.
Now, one thing which is very important, and sir was rightly pointing it out, is that abrogation of 370, so to speak, assume that it happens, still does not create a ground for secession, because legally that is incorrect. Accession happens through a separate instrument, which is the instrument of accession under the Indian Independence Act of 1947 under section 6. Therefore, that's a different document altogether. 370 is only a question of power sharing, degree of autonomy. That's it. Now, point number 2, the question of plebiscite in Pakistan. Pakistan only needs to read the UN resolution of August 13, 1948. There are 3 parts to that particular thing. Part 3 is truce agreement, where specifically the UN Security Commission that was appointed for India and Pakistan clearly says, Pakistan shall vacate POK, all its troops, and all the tribesmen as well specifically find reference there. So they have to vacate. Subsequent to which, India shall be allowed to retain its troops at the very least to ensure that status quo is maintained as it existed at before the invasion, so to speak. And then comes the question of plebiscite.
Right.
Now, after having agreed to that particular truce agreement, which was, let's assume it's a contract, you have reneged on that, you have not acted on it, as a consequence of which all bets are off. As far as we are concerned, there is no question of a plebiscite. Most importantly, when the Constituent Assembly of J&K categorically resolved through its constitution that Jammu and Kashmir shall and remain an integral part of India, which is among the first few provisions of the Constitution of 1956 of Jammu and Kashmir. According to me, that's a plebiscite in action.
Right.
Because the State Assembly has taken a decision. And when they took a decision, they were not speaking only on behalf of the, let's say, Kashmir, which is under Indian control and, let's say, under Indian ownership. Jammu and Kashmir has been defined throughout as Jammu and Kashmir as it existed at the time of the Treaty of Amritsar. Therefore, they have spoken on behalf of everyone.
Sure.
Therefore, there's no question of a plebiscite, there's no question of a referendum.
Right.
We are very clear as far as that is concerned. Most importantly, I think 35A, once it goes out, it also allows for demographic balance to be restored to that place. When Kashmir acceded to India, the population was 4 million, out of which 1 million was the non-Muslim population. The division was 76 and 24. Today it is dwindled. So any question about the aspirations of Kashmiris is not possible unless and until the demographic balance is restored.
Right.
Therefore, while we look out for Shia Muslims in Ladakh and Sunni Muslims in, let's say, the valley, you also have to bring back the Kashmiri Hindus from wherever they are, give them the confidence that they will not be hounded out or they will not, and there will not be another exodus, and then we can have a question.
Sure. Okay, limited time on the program, so quick comments from both my other panelists as well. Satya Prakash, what are the challenges going forward for the government in dealing with the problem in Kashmir?
Well, the first and foremost problem at this juncture is law and order problem, because all the political parties in the valley, they are dead against abolition of Article 35A and Article 370. So first and foremost thing is it. Second is having some sort of political dialogue and reach out, as Mr. Banerjee has pointed out, because without that, it is not just a security problem. Security is just one aspect because of cross-border terrorism. But in the first place, there is a sense of alienation that needs to be addressed. And root cause perhaps was this, because it acted as a sort of psychological barrier, which generally people in Jammu and Kashmir would not, they think that they are separate, and some sort of separatist feeling it generated. Once it is gone, so the psychological barrier would be gone. And second is people from outside, the industry people, those in business, they would like to invest in Jammu and Kashmir and maybe tourism industry and other industries also, Jammu and Kashmir handicraft and everything. Right. If people from outside the state, and particularly people from the industry, they invest in the state and they generate employment, once these aspects are taken care of, the opposition to abolition of 35A or 370 would maybe in the next couple of years, it would go and things will settle down.
Right. So Mr. Banerjee, close the show for us with your concluding remark on the best way forward.
Well, broadly I'm in agreement with my other panelists, and it would depend on how the situation pans out. And I'm sure the government, the federal government would be conscious of this and would be taking some measures very quickly. Maybe the Independence Day speech of the Prime Minister may touch upon this concept of outreach to the Kashmiris. And this could be done in various ways to attract the youth there, to, for example, having some very attractive, sports programs, and right. Also the focus of, diplomats who are even Western diplomats based in India, if they could be convinced that these are right measures going the right way forward for a resurgent India, which is concerned about the youth in Kashmir, and they may be taken on conducted tours to see how such programs are being dealt with or done. I think such type of measures may help the government to overcome the negative feelings that are likely to be propounded by the disgruntled politicians in J&K for some time now.
Right. All right. On that note, then we'll call it a wrap on this edition of The Big Picture. Thank you to all my guests for joining me on the program and putting things into perspective for us. That's it from me. See you again next time.